How many times can a key witness suddenly end up in hospital just days before facing tough questions? Be honest, genuinely. At the center of this latest controversy is businessman Suliman Carrim, and what unfolded at the commission today has raised even more questions than answers. There was no holding back from the evidence leaders. The possibility of criminal prosecution for Carrim's alleged obstruction of the commission was openly warned of. Why? Because important financial documents, firm records, and outstanding questions surrounding million-rand transfers have still not been turned up. And then his lawyers came across something they had never anticipated. Stay until the end of this video because this showdown could reshape the entire view of the commission.
Mr. Carrim has been hospitalized, so he can't be here today. But we do want to place on record certain issues relating not just to his non-appearance, but to what's happened before. And essentially, Chair, you'll recall that when Mr. Carrim testified back in April, there were a number of documents and details that he undertook in testimony to make available to the Commission. Those details were thereafter incorporated into a Regulation 10.6 notice that was dated 8th May 2026 and that was served on Mr. Carrim by the Sheriff on 12th of May. And they related to the payments of 1 million and 1.12 million, which Mr. Carrim said he was unaware of, payments that were made to Medicare 24 Tshwane District by Tasmika Construction. And certain information relating to those payments was sought from Mr. Carrim. It was sought first in a notice on a notice dated 8 May, served on 12 May, and then a supplementary notice dated 20 May was sent to Mr. Carrim and his attorneys when there was no response to the earlier notice, which repeated that request and then essentially tabled all of the details that Mr. Carrim had undertaken to provide to the Commission but had not yet done so. And some of these are fairly routine details. So, for instance, details of the accountants, auditors, and accounting officers of various of his companies. The dates of appointment and removal of Mr. Kerr and Mr. Mohammed, who he testified who had been appointed with certain rights in relation to Medicare 24 at the instance of Mr. Carrim. Audited financial statements for his companies, or if audited financial statements didn't exist, we asked for unaudited financial statements and an explanation of why there were no audited financial statements, and there was an undertaking that he would provide us with a copy of an agreement or a draft agreement between himself and companies of Mr. Mamela, and also communications between himself and Mr. Carrim. So that was all tabled in a supplementary Rule 10.6 notice dated 20 May. And thus far, we've received no response to that either. There is a further issue, which is after Mr. Carrim wasn't available to testify at his last appearance and is now, after he wasn't available to testify at his last appearance, we asked that Mr. Carrim make himself available for examination by a specialist appointed by the Commission to confirm that he was indeed not medically fit to testify. And he hasn't yet responded or hasn't yet complied with that request. So we sit in a situation today where this is the second appearance for which Mr. Carrim has been medically unfit to appear. We're running out of time. And there are a whole succession of details and documents which he undertook in evidence to make available, which were then demanded of him in terms of notices and which have not yet been forthcoming. So we accept that he is not available to testify today, and that he has been admitted to hospital. So we can't have him here today. But what we would ask of the Commission is to postpone his appearance to the 15th of July. And our request, or our intention in relation to what will happen on 15 July is, obviously, if Mr. Carrim is here, he will be questioned. It will be the end of his testimony. If he is not here and is still, on his version, medically unfit, we will no longer seek his appearance on the 15th of July. But if he has subjected himself to independent examination by a specialist appointed by the Commission, and that independent specialist confirms his incapacity to testify, we won't ask for him to be called again. We won't have time to hear his evidence, but we will ask the Commission to make its findings in relation to all matters relevant to the evidence of Mr. Carrim on the basis of the evidence that he has already given, and on the basis of the evidence that he has thus far not answered, and his failure, if the failure still persists, to furnish audited financial statements, details of auditors, and the like. If Mr. Carrim does not agree to be examined by an independent specialist, then we will ask the Commission to recommend that he be prosecuted under Section 5 and 6 of the Commissions Act and Regulation 12(2) for hindering the proceedings of the Commission. And we will also ask for the Commission to make its findings on the basis of the evidence that we've heard thus far from Mr. Carrim, but no further evidence.
Regarding that proposed criminal process, I would imagine that the mental element would consist of intent. And are you basically saying that's something that would then have to be investigated down the line? It
would have to be investigated. I don't want to address argument on that, because I'm still hoping that one of two things will happen. Either Mr. Carrim will have recovered and will be here in 3 weeks' time, or his medical state will have been confirmed.
So that's an issue.
So it may never arise, but I want to give notice now that the Commission, or the evidence leaders at any rate, I can't speak for the Commission, the evidence leaders are taking this very seriously, because we regrettably are of the view that thus far we have not received the necessary cooperation.
I guess at this stage I'm going no further than just raising this so as to start thinking about it.
Indeed, I'm not asking the Commission to make any decisions at this stage, but I do need to place it on record so that Mr. Carrim and his legal team know where we will be going.
Okay, all right. Please continue.
So for present purposes, all that we would ask from the Commission is a postponement to 15 July. That's all I have to say at this stage.
Thank you, Mr. Chaskelson. Yes, Mr. Premhead.
Thank you, Chair. Good morning. 3 very brief submissions in response to what my learned friend has said. The first one on the documents and the alleged non-compliance. My learned friend made reference to 3 dates, 8th May, 12th May, and 20th May, when the relevant instruments requiring those documents were delivered to Mr. Carrim. I would just point out that as far back as the 14th of April, 2026, in response to the Commission's letter on the 14th of April 2026, at page 3, paragraph 11 of that letter, Mr. Carrim's legal representative said the following after Mr. Carrim's initial hospitalization. We further advise that we as the legal team are dependent on Mr. Carrim's family to receive updates regarding Mr. Carrim's condition, which depends on the medical treatment and advice he is presently receiving. We will update you as appropriate when we receive the information from Mr. Carrim's family. Now, I highlight that only to point out one thing, and that is when Mr. Carrim was initially hospitalized, it was explicitly stated to the Commission that the legal team, as creatures of instruction, cannot act without instructions from their client. And if their client is medically indisposed, particularly in circumstances where his medical indisposition started ahead of May, it started in April, it stands to reason that this allegation of not complying must be put in its proper context, that it's not willful, and it's because the ability to deliver those documents is directly hamstrung as a result of Mr. Carrim's medical condition and all the subsequent correspondence and all the subsequent medical reports, of which there have been 4 reports, which make it abundantly clear that Mr. Carrim is not only able to attend the Commission, he's also not fully able to engage with his own legal team regarding his ability to give instructions. So that's the first point I want to make, Chair. The second point I want to make, Chair, is in respect of this independent medical examination request that has been now raised on the record by my learned friend.
But which I understand was raised previously. But
yes.
Of course, I do hear you say on record.
Yes.
But as a matter of fact, it was raised through correspondence.
I don't take any issue that this is my first occasion of
yes.
having notice of that.
Yes, all right.
I just want to address the reference. Excuse me, I just want to address what my learned friend said, Chair, in the context of raising it today. The Commission sent our client and his legal team a letter yesterday on the 24th of June where this was raised, and I'm not sure if my learned friend or the Commission itself have seen our response to that letter, also dated the 24th of June. The only thing I want to emphasize from that 24th of June letter, Chair, is what is...
Sir, before you go on, are you saying that the possibility of subjecting Mr. Carrim to an examination by a specialist of the Commission's choice was raised for the first time in yesterday's communication?
No, I'm not saying that.
Yeah, I'm asking that so that it does not appear to all concerned that's what you are saying.
Yeah. I'm only addressing the content then of the letter of yesterday as it responds to the letter of yesterday from the Commission, which I understand my learned friend to be foreshadowing with you today.
I understand you, but I just want the fuller picture out there. That it was not the first time yesterday.
Unequivocally, I say on the record it was not raised yesterday for the first time in the correspondence. It had been raised prior, and the parties have been engaging on that. I'm just limiting it to the exchange yesterday and as it comes in front of you today.
Yes.
All I want to say, Chair, is that in respect of that contention or submission that is an available avenue to the Commission, in our letter of yesterday, particularly paragraph 10, you would see that certain issues were raised, and those issues were raised with the purpose of saying, and I place this on the record as well, is that once that is clarified, our client can then be informed of what the position of the Commission is, and he can exercise his rights to the extent that he can, and give us instructions to the extent that he can. So,
may I just raise this in the context of claims arising from, for example, bodily injury, medical malpractice. Such examination happen as a matter of course. One of the issues raised in the letter we received, I think, at night, I might be mistaken, is the question whether there is a suspicion that, I'm paraphrasing.
yes, I accept.
that Mr. Carrim is not in fact suffering from what
Yes.
is stated by the doctor.
Yes.
Bearing in mind what I've just said about this happening as a matter of course, would
Yes.
you say in those cases it happens because there are suspicions?
No, but may I qualify my answer on the following two propositions?
Yes.
The first one is the regime that the chair is putting to me is firstly in the context of medical negligence claims or damage from medical negligence, which we know arises under a prescribed procedure under Uniform Rule 36. And related proceedings under Uniform Rule 36, where there's the contestation between parties and the need for independent medical examination to determine the extent of damages claimed and verify all of those. Without going into the merits of that, all I'm gently going to say at this point is that firstly, we're not in that terrain, and secondly, there's no equivalent procedure in the regulations, the Act, the rules, or the Commission's own rules that remotely cater for an equivalent procedure.
I saw that your letter actually raises that, and it's asking for the legal prescripts
Yes.
that make it possible for the Commission to
Yes.
insist on something like
Yes.
this. The prescripts governing the Commission's process provide, for example, that the chairperson may regulate the Commission's process. Based on your point that nothing comes anywhere near entitling the Commission to order something like this, would you say that that power, for example, the regulation power, would not be sufficient for the exercise of such a power by the, or to make such a direction by the Commission? If so, why not?
May I qualify my answer first by saying I'm addressing the chair's questions to me in general and in a hypothetical discussion. So nothing that I say must be construed as committing my client to a position one way or another. I understand the chair and I are having a debate about remit and powers. So I just want to make that
It's just a virus issue.
Yes,
you are
yes,
raising a
yes.
virus issue, and I'm engaging you at that level.
And because we don't know what the Commission's view, and when I say the Commission's view, I mean the evidence leader's view of the medical evidence is, and its deficiencies or otherwise, I need to make that clarification that I'm not committing my client to a version preemptively without knowing what the Commission's stance is. That's my clarification. But Chair, and this is still the first issue I want to address, you know that previously when we've appeared in front of the Commission, we raised an objection, to example, for a certain line of questioning that our learned friend was putting to the witness. My learned friend, Mr. Bana, was appearing on that occasion. Chair is nodding his head, he remembers that very well. And one of the preliminary objections raised to the line of questioning with the reservation of rights was that the line of questioning fell outside the mandate of the Commission, and that we reserved our client's rights to place that in issue at the appropriate time. Now, Chair, that answer is background context in response to your question on V-Rays, because in as much as obviously you have on the desktop version, you have an unfettered power to create the appropriate...
It can never be unfettered.
Well, that's the point. Well, Chair helpfully preempts me to where I was going to go, is the question of the degree of the fettering of your power is tied directly into the issue of the mandate. So without going into a full debate as to whether or not that falls into or outside of your mandate, I'm just flagging at a broad level of proposition that that's one concern we have. But also there are other concerns that we have, that they are potentially less intrusive means that the Commission has available to it, other than to subject our client to medical examination by a medical expert that he does not necessarily consent to. It's a compelled examination. That's how we understand the proposal being put, and that which potentially breaches his medical rights whilst under treatment by a treating doctor in a manner that potentially breaches sections 14 and 15 of the National Health Act. And that creates a question of vires and competency insofar as the exercise of your discretion is concerned if you're invited to do that. So that's my first bundle of concerns, if I may, in response to you, Chair. The second...
And,
sorry,
if a ruling or directive from the Commission were to direct that Mr. Carrim avail himself for such an examination, but be couched in a manner that does not make it obligatory that he do so. But of course, bearing in mind the fallback position that Mr. Shaskalson has placed before us, in the event that Mr. Carrim does not do so, would that take care of your concerns about the statutory prescripts that you are referring to? Because then he can just opt out and say, I'm not going to do it. At this stage, this is just engaging you at a legal level.
Yes.
I'm not saying that's the way I'm going to go. Yes.
No, Chair, can I say, firstly, I'm indebted for this exploratory discussion in the way that it's occurring, because it's helping clarify for me, and also I would hope for the Commission's evidence leaders, about these concerns which are legitimate concerns. And so again, the first point is I'm not committing my client to aversion in response to what Chair has put to me, but can I say that I have two responses to this hypothetical directive. The first one, of course, is it depends on the nature of the request, once specified by the Commission, for such a ruling and directive, which my client must then be given a full opportunity to respond to. So I can't in abstract just say, well, if you try to design an equivalent confidentiality regime, like Chair will know from the HSF judgment, in our circumstances, attenuated for consent, that I can agree to it. I first have to see what the Commission's position is. In theory, that might not be objectionable, but it might still be objectionable if there's a vires challenge. So the creation of the regime does not answer the fundamental question if it's still ultra vires. So that's as far as I can probably take it. The second thing I would say is that if it's attenuated to being voluntary, that might not be objectionable in and of itself, but then it depends on what weight will be placed on the election that is otherwise voluntary to ask the Commission to draw adverse inferences against my client for not participating in a voluntary request. Because remember, in the recent exchange of correspondence between my client and the Commission's position is that we've asked you, it's reasonable, you're choosing not to do it, and if you don't do it, we're going to ask the Commission to make inferences against you.
Let us say you were the decision maker, and the upshot of all this was that Mr. Carrim ends up not testifying at all as a decision maker. And faced with the evidence that you have, how would you handle that evidence? I think it would be quite odd if, for example, we were suddenly to say, a lot of evidence was heard before the Commission, but because Mr. Carrim could not have his last word on it, therefore, everything that relates to the bit in respect of which he did not have his last word will just be ignored altogether. So how, if you were the decision maker, how would you handle the situation? I'm raising this in the light of your point about adverse inferences being drawn.
Chair, I think we must disaggregate the adverse inference point. I'm talking about the adverse inference in the specific instance of not participating in a voluntary medical examination. That's what I was addressing. What Chair is putting to me, I think, is something slightly different, which is like, and I've not been an acting judge yet, but when that happens, should it happen, obviously, Chair, what you're putting to me is the ordinary decision-making process that a judicial officer goes to in circumstances where you will weigh probability, credibility, admissibility, and so on. And if you draw an adverse inference at the end stage of of your report writing in analyzing the evidence, that can't be objectionable. That's the ordinary rules of evidence as we understand it. So if at that stage you draw an adverse inference, for whatever reason you draw an adverse inference, I don't think in principle that there can be an objection to that exercise of inference drawing. I was addressing the adverse inference point about the prior step regarding the voluntary election. So, in direct answer to you, Chair, if I was the decision maker and it was argued in front of me that an adverse inference must be drawn, that Mr. Carrim is a naughty person, so to speak, because he didn't participate in the voluntary disclosure.
You see, that's what I'm trying to get out of the equation. There is an inference is being drawn and becomes adverse because of one saying, because of his failure to testify, we are drawing an adverse inference. That's what I'm trying to say. Let's get that out of the equation and just look at the evidence that's before the commission,
yes,
and then decide what to make of it, just as evidence
yes,
that's before the commission. Of course, it will be a fact,
yeah,
that certain allegations have not been answered,
yes,
and one takes it no higher
yes,
than that.
No,
so it's at that level that I'm engaging.
Then we're at Eden.
Not an adverse inference based on the failure to testify, in the sense that maybe he was being naughty. Why would he not testify?
Yes, yes.
So I'm engaging you at the level of the reality is that here is evidence to which there is no answer, period.
But then we're at Eden, because that's what I was trying to draw the distinction on. If Chair puts it to me in that way, and that's the disaggregation that I was, with respect, motivating, you're not elevating the non-participation in the voluntary examination process to say, that's the evidence that you're naughty, I'm drawing the adverse inference. I can accept that. But if it's the second one, which is that it's unanswered allegations and therefore I'm drawing inferences because of the failure to answer, that's the ordinary laws of evidence.
To get to that, what you call an adverse inference, to get to that, I think we would have to first make findings as to Mr. Carrim's condition.
Yes.
Otherwise, it's just difficult, I think. I don't know what Mr. Chaskalson will say.
Agreed.
Yeah,
because you'd have to consider potentially credibility or the, as I was saying, credibility, probability, veracity of the version. You'd have to engage with all of that. All I was simply saying about it depends on where that comes in. If it's the first step medical examination, that's where I may have a problem. But if it's the second step, which is what Chair is putting to me, unanswered allegations and what flows from unanswered allegations, to me that's the ordinary principles of evidence. That can't be objected to. Unless, of course, there's a question of Audi or whatever,
All right, you may continue,
please. Thank you, Chair. But the second point I was going to make in respect of these the medical examination and less intrusive means is that, and I say this with due respect, because we're not in Uniform Rule 36 territory, there is no comparable direct access to a witness as far as I understand it. My understanding, and you'll know, for example, in the litigation involving President Zuma and the competency of his medical certificate that he used to excuse himself from another commission, if I'm not mistaken, which went originally in front of Judge Pillay, who might have acted with Judge in the Concourt, but is from the KZN division. There, the contention was not when the commission, that commission, I don't want to call it the Zondo Commission, but you know which commission I'm referring to. When that commission had issues with the medical certificate and the medical fitness of the witness or otherwise, they had to impugn the medical certificate as the first step and potentially the person who authored the medical certificate, because that's the evidence upon which the witness relies to say, I should be excused from giving the evidence. So why I mention that is because what our learned friends say is that because they've come up against this medical certificate as they have, they must go directly to the witness and subject him to a medical exam from someone other than the doctor of his choosing. Whereas what they could do is they could engage the medical practitioner themselves. If they wanted to, they could have, we could have, I say we in the sense of if chair gives directives to that effect. And again, I'm not committing myself to this version, I'm just theoretically testing the proposal put in front of you, is that we could have an in-camera hearing, because obviously we'd need to test the fullness of that confidential medical evidence, so it can't be for open public consumption. But then that's what we do, and the commission might choose to cross-examine the particular medical professionals. They might wish to lead the evidence of their own medical examiner, who might give an expert view of the expert view that we've tendered. We might want to cross-examine their own expert. So that what I'm saying is that I'm not immune to the Commission's concerns about concluding the evidence of Mr. Carrim. But we've played open cards with the Commission to the extent that we can, by providing all the correspondence, by providing 4 medical reports, giving all the details of all the treating doctors, and before we must leapfrog to subjecting a person to a compelled medical examination, or potentially a voluntary one like Chair says, we must think about the balancing exercise of constitutional rights. And if there is less intrusive means that can nonetheless enable the Commission to do its job, then we would argue from the perspective of proportionality and reasonableness and balance, then that's an available mechanism. May I just make my last main submission? But before I do that, Chair, I don't know if you want to...
Just to say what Chair posits.
Yes.
I think to say says sounds stronger to me. I think there's a nuance there.
Yes, no, then I withdraw every use of the word says, and I rather use the word posits. If the transcriber can edit the transcription, that's perfectly fine.
No, they don't need to. It's part of the engagement.
Yes. No, I accept that. And I'm grateful for the clarification, Chair, because also what I'm doing is I'm trying to be helpful to you, Chair, and the Commissioners by engaging the debate and giving as cogent an answer as I can, hamstrung by the fact that I can't commit my client to a version in the absence of knowing the Commission's position and without instructions. So that's the rock in the hard place. The rock on my right and the hard place on my left, perhaps, that I'm stuck between in trying to engage you, Chair. So that's as far as I'm trying to take it. My third and last main submission, if I may, Chair, is that I've heard what my learned friend said about the recommendation for prosecution. Chair already identified mens rea as the requisite element and how that would need to be investigated, and then the prosecution would flow. All we'd point out is we've also addressed this in our letter of yesterday, which I take you got probably very late last night, if not early this morning, and we did say that if that's going to be the case, that the Commission, for whatever reason, chooses to make a motivation to the Commission that a recommendation be made that our client is prosecuted, that we get an opportunity to address the Commission before an adverse decision is potentially made against him, because that's Audi Rights 101. So Chair, that's to respond to what my learned friend said regarding everything else other than the 15th of July date. On the 15th of July date, we are in your hands and we will do as directed. Thank you, Chair. I'm indebted, and I know I've taken a long time, but thank you.
Thank you, Mr. Prem. Mr. Shaskalson?
Chair, I don't want to respond now because this is a debate, if it is ever going to arise, for another day. But I do want to place on record that we don't accept many of these submissions. And in particular, the one worrying thing that we see is what the medical reports disclose is that Mr. Carrim has not been hospitalized continuously since April. He tends to get hospitalized just as his appearances before this commission are scheduled. And that is worrying. And it's particularly worrying in the context of a situation where very basic, quite aside from his appearances, there are very basic requests for some documents to be furnished, like financial statements. It doesn't take much to issue an instruction for financial statements of a company to be made available to this commission if you're not in hospital. And what we see is a simple refusal to comply with these notices, coupled with a pattern of, as an appearance date appears, suddenly Mr. Carrim needs hospitalization. Now, it may be perfectly true. It may be that by coincidence, or possibly not by coincidence, his medical condition compounded by the stress of an imminent appearance requires his hospitalization. I'm not saying it's not true, but it is worrying. And what is particularly worrying is that very, very basic requests for information have been outstanding since Mr. Carrim last testified, at a time when he was certainly fit enough to testify, fit enough to travel outside of the country, and we still wait for the documents that he promised us when he gave evidence. I don't want to say any more now. I'm hoping this never becomes an issue that we need to take further.
Now, thank you, Mr. Shaskalson. For purposes of now, what sort of...
all we want is a postponement
just
until
a postponement
the 15th of June. Nothing
period,
more.
nothing more.
We put stuff on record now so that
Thank you.
Mr. Carrim and his legal team know what our concerns are, but all we want is a postponement until 15th
Thank you,
June.
thank you. The hearing of Mr. Karim's testimony is postponed to 15 July 2026. You are both excused.
Thank you, Chair.
Thank you.